The Constitution and saving our future. Supremacy Clause, Article 6, Clause 2. The Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution, or laws of any state to the contrary notwithstanding. What it means: federal law supremacy. Federal laws and treaties take precedence over state laws and constitutions. It's binding on state judges who are required to uphold federal laws, even if state laws or constitutions conflict. Uniformity ensures a unified legal framework across all states, preventing states from enacting laws that contradict or exceed federal legislation. Commerce Clause, Article 1, Section 8, Clause 3. The Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes. What it means: Congress has the authority to regulate trade and commerce that crosses state lines, to manage trade between the United States and other countries, and commerce that involves Native American tribes. Multiple Supreme Court cases have further defined its powers. Gibbons v. Ogden, 1824, established that the federal government has exclusive power to regulate interstate commerce, overturning and ruling a New York State coastal license unconstitutional. Wickard v. Filburn, 1942, expanded the scope of the Commerce Clause to include activities that have a substantial effect on interstate commerce. United States v. Lopez, 1995, limited the reach of the Commerce Clause, ruling that Congress could not use it to regulate non-economic activities that have a minimal impact on interstate commerce. Contract Clause, Article 1, Section 10, Clause 1. No state shall enter into any treaty, alliance, or confederation, grant letter of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. In Fletcher v. Peck, 1810, the court defined the Contract Clause, ruling that even the state of Georgia could not invalidate a land sale because it would violate this clause of the Constitution. This case established the principle that states cannot pass laws that impair the obligation of contracts, thereby reinforcing the protection of private property rights and the sanctity of contracts. In Dartmouth College v. Woodward, 1819, New Hampshire attempted to change a charter given to the college by King George III in 1769. The court held that the college's charter was a contract between two private parties, and the state action violated the Contract Clause of the Constitution. This case established the principle that states cannot impair the obligation of contracts, which was crucial for the development of American corporate law and the protection of private property rights. Our Constitution was written to build a nation and to protect the citizens from its own government. It is not there to restrain the citizen. It is there to restrain the government. Did you know that there was no Bill of Rights in the Constitution, nor were there any amendments that granted you additional rights? It's because you were born with inalienable rights that the government can neither grant nor deny. It's when the government doesn't follow the supreme law, that is when we run into trouble. I apologize for making you wade through all these legal proceedings, but they are needed to illustrate the concepts of our Constitution. If you value your life and your freedom, you will continue to follow along. For more than 30 years, I have been writing about these freedom issues. The government, et al., has been trying to destroy the Second Amendment and to take away our mobility. Well, that day has come. The new California-style emission standards are now going into effect in California, Massachusetts, New Jersey, New York, Oregon, and Washington. Vermont is scheduled to go into effect in 2026, and Colorado, New Mexico, Rhode Island, and Maryland to follow suit in 2027. California has already banned ice-powered lawnmowers, leaf blowers, generators, and even non-electric barbecue grills. They have banned the sale of ice-powered new motorhomes. Washington State has just banned the sale of new motorhomes and trucks of more than 8,500 pounds gross weight powered by gasoline or diesel. All of these states are following this program with the goal of 100% zero-emissions vehicles allowed by 2035, with phase-in of these programs starting January 1st, 2025. Happy New Year! Okay, so you say, so what? I'll just go to a neighboring state and buy my vehicles there. Well, think again. You won't be able to register that vehicle in these states. So unless you want to move, you're out of luck. That brings us right back to the Constitution and the Second Amendment. Haven't you wondered why so many states are trying to take your guns and rights away? Have you noticed that many of these same states are anti-Second Amendment?
It's not a coincidence. It's been planned for 30 years.
They know that the only way to get Americans out of their private vehicles was to disarm them first. To my fellow South Carolinians, don't think you are getting away scot-free. We are so asleep at the switch that we just participated in a major election where 60% of the candidates had no opponent on the ballot. We were told it was a great election and all of the people voted and performed their duty as citizens, but in the majority of cases we had no choice at all. Today's technology is amazing. We knew the winners, weeks before the election.
Let's see Russia or China top that.
And don't think you are off the hook. Our rerun legislature has introduced Bill 691 to adopt these same regulations to ban all non-zero emissions vehicles by January 1st, 2035. All of these laws and regulations are unconstitutional under these 3 clauses of the Constitution alone. This cannot continue. We must change the system and replace our so-called representatives. As I am writing this, I just received a news flash from New York. It seems that Governor Hochul just signed the Climate Change Superfund bill into law. It will charge gas and oil companies $75 billion over the next 25 years. It will start penalizing companies based on emissions from the years 2000 through 2018. This law is facially unconstitutional and absurd on too many levels to list. If we don't replace these people now, our country will not survive. As always, the basis for fixing this is in the book.